Uh, Hello, and welcome to our Glaholt LLP Leadership Series on the new Construction Act 101. And thank you very much for attending and being here with us. We're going to have four partners of Glaholt LLP presenting to you on the new legislation, where we are in the process, and give you our takeaways on some of the major changes, legislative reform that we're going to see over the course of the next year and a half. I'm going to start. I'm Brendan Bowles, for those of you who don't know me. I'm going to start by giving a bit of an overview, and I'm also going to address how the new provisions are going to transition in, and also some of the new provisions related to holdback. My partner John Margie is going to go next. He is going to address one of the major changes that's going to come into place as of next year, which is the prompt payment regime. He'll be followed by our managing partner, Keith Bannon, who is going to talk about the big change in dispute resolution, adjudication, which we're going to see come into place in 2019. And last but certainly not least, partner Andrea Lee will go over the new approach to liens and the changes that are associated and related to that. And I think also, just because it is a bit of a tricky point, deal with some of the transition questions as well, which is going to be interesting, I think, starting as of July 1st. So that's the approach for today. We hope that there are some questions. We'd be very interested in receiving your questions, actually, so please do submit them using the chat box function. I'm technologically incompetent, but there are competent people here who will be able to handle that and know what that means. But what we will do then is, as the questions accumulate in the chat box, once all four of our remarks have concluded, we will then move into the questions. And as I say, we do indeed hope there are some, because we would like to receive them, and I think that's where we're all going to do some learning. So I'm going to, as I say, start with the introduction and overview. And I wanted to start, interestingly, by just going back in time 4 years. April 2014. The world has changed a lot since then. I just think, man, how have things changed right here in Toronto? We had Rob Ford was our mayor in April 2014. The Toronto Maple Leafs were still completely hopeless. They're not anymore. I'd like to stress that. And we had at Queen's Park a bill, 69, which attempted to introduce the Prompt Payment Act to the construction industry in Ontario and failed. Now, I gave you some context. A lot has happened since then, but in a relatively short period of time, we've gone from an attempt to introduce a Prompt Payment Act that didn't pass to having really now passed and shortly to be implemented whole-scale reform to the Construction Lien Act. So why do I start there? For a couple of reasons, and I think it's helpful to understanding our remarks as we go through this today, why the Act has been reformed in the way that it has and how we're likely to see it play out, is that it was largely driven by the prompt payment effort. Definitely as a political issue, I would argue that it was prompt payment that gave this process all the momentum that it had and has into having new legislation passed. Without that, and without the support that it had in the industry, I don't think we would see this. But I think the other thing that became apparent through that prompt payment legislation debate was that there was a perception that the Construction Lien Act was a bit archaic, perhaps, and not well suited to resolving some of these payment issues. And indeed, some people might go so far as to say that it was perhaps perceived as more of an impediment to the orderly flow of cash on a construction project, as opposed to something that would facilitate it. The prompt payment bill, and again, I promise I'll move on past it quickly, but it did proposed to tinker with a couple of sections of the Construction Lien Act, and I think that opened the door to people. The government in particular was very receptive to, you know what, let's not tinker with just a couple of sections. Let's do whole-scale reform. The last time we did it, 1983, the construction industry has changed significantly since then, including the way in which construction projects are managed, the way that they're delivered. The Act clearly was falling a bit behind the industry in terms of where they were at. So the timing was really right for this all to come together. Now, one of the flaws with Bill 69, at least it was perceived that it wasn't as consultative as it could have been. There were certain stakeholders who maybe felt they were caught somewhat by surprise and maybe hadn't had an opportunity to weigh in on the process the way they wanted to. So this time, the government did commission an expert report led by Bruce Reynolds and Sharon Vogel, who consulted broadly with several stakeholders. And that generated a report in September 2016 that contained 100 recommendations that were very, very broadly consulted with in the industry. Led to, I would say, 97 or 96 of them, I think it is, that actually found their way into this act that received royal assent at the end of last year. We now have draft regulations that have been released. They're available on the ministry website. There was another period of public consultation quickly over the course of a month that was closed in March of 2018. And right now the government is considering those comments from various groups on the draft regulations. So we're very quickly in a position, I would argue, from back in 2014 when the last effort failed to where we are now, to having whole-scale reform of the Lean Act. Most of it will be in place as of July 1st, 2018, including the new title, by the way, which I think should not be lost in all this. It's going to be the Construction Act, no longer the Construction Lean Act. So if you're one of those folks that still calls it the Mechanics Lean Act, you can just skip right past Construction Lean Act and just go right to Construction Act. But more importantly, I think when I talk about the transition and when Andrea does, it'll be a nice way to keep it in your mind that there are certain projects that are going to be still subject to the Construction Lean Act, in other words, the existing legislation. There'll be other projects that are subject to the Construction Act, the new legislation. And then in October 2019, the radical changes, as I called them, adjudication and prompt payment, will start to come into force. So quickly, the transition rules, how are they going to work? Essentially, it's this. If you have an existing project, existing contract, even if it's just at the procurement stage, the Construction Lean Act will continue to apply. So what that means, obviously, is that don't throw out your Construction Lean Act books. We're going to have them likely for the course of the next few years as some of these projects that are currently underway continue to operate under that regime. But you'll start to see the Construction Act kick in, for example, on some of the issues Andrea is going to address at the conclusion of our remarks as of July 1, 2018 for new contracts, including subcontracts that fall under that prime contract. Leases, an interesting one. I flag it because it does kind of make sense from the perspective that they want to transition gradually, obviously, that existing leases will still be subject to the Construction Lean Act. But as we know, leases can be very long-term sometimes. So, what about a 50-year lease, for example? Are our grandchildren going to have to learn about the Construction Lean Act if they're advising landlords? We'll see how that plays out. But I think at least in the short term, if you're advising landlords or if you're a landlord, the Construction Lean Act will continue to apply to existing leases. And I think we're going to see the new regulations in place that affect these sections in place by July 1st, 2018 as well. So the big changes, October 1, 2019 being the key date. Obviously, the rollout for that is very gradual. There's a lot of work to be done establishing the nominating authority for adjudication. The regulations, the initial drafts have been released for adjudication, but there's still a lot of work to be done. There's still a lot of area to be covered. So we'll see that come into place in 2019. And again, bear in mind, that's only for contracts as of October 2019 and later. That's how the transition is going to work. So the regulations, which I talked about quickly, this is the meat and potatoes of the Act, if I can say that way. How it works, what makes it work, the forms. The drafts are on the government website now, including procedures for actions under the jurisdiction and procedure part of the Act, and general regulations for everything else, including the important monetary thresholds. Those were fairly well developed already. There's been the consultation with stakeholders, and there's going to be a very intense period to get those done for July 1st, in my view. The government has sort of left the door open. I threw the quote in there. I thought it was delightful bureaucratic language. But I don't see any option. They have to have those in place for July 1st so it can start applying to new contracts. For example, forms, there's going to be a form for notice of intention to set off, which is a new provision under the Act. There's going to be a form for notice of termination of a contract, which is a new trigger for lien rights. They're going to have to get those in place, there's no doubt. Certain procedural revisions, which we'll perhaps leave to another day for us to talk about the details of that. But also the new monetary thresholds, very interesting, just the big ones that kind of leap out at me. Again, bearing in mind that these are for July 1st and later contracts, not current work, but you're going to have now new increments of $1 million as opposed to $500,000 for the test for substantial performance under the Act. Completion, which is the lesser of $1,000 in remaining contract price or 1%, is now going to be the lesser of $5,000 or 1%. You're going to have bonding off of liens, very important change. The maximum amount of security for costs that can currently be required is $50,000. It's going to be $250,000 going forward. So again, as you can imagine, these regulations have to be in place as of July 1st, and indeed they will be, and indeed I have no doubt right now there's intensive work going on right now, considering all the input from the various stakeholders on them. Adjudication, there are some very preliminary regulations out. Still a lot of work to be done under that category, I would say. And indeed, that's why it's being rolled out gradually. There was, I think, wisdom in getting the legislation passed quickly, but also wisdom in implementing that very fundamental change gradually. Not to mention prompt payment. Again, another one of the very gradual rollouts for 2019. So, holdback. I'd like to conclude my portion of the remarks by just talking about some important holdback details. The main one, I think, that kind of comes out of the desire to reform the way payments are handled on a construction project was to make release mandatory, not permissive. And this, I think, was perceived as being necessary to respond to a situation where perhaps people were not being forthcoming with the desire to assert a set-off claim against holdback monies. And as a result, there was definitely a complaint, at least in some sectors, that you might have a situation where people are expecting to receive their holdback, don't register a lien, the date to have holdback paid, or liens registered comes and goes, the holdback's not paid because now we find a set-off is being asserted and people are left without recourse. That was perceived, I think, as being unfair. This is an effort to sort of get people to put their cards on the table. So the way it's going to work now is, as I mentioned earlier, one of the new forms is going to be a notice of non-payment due to set-off. The owner is entitled to deliver that form, and indeed required to, if they intend to assert a set-off, which then puts the onus on the contractor once they receive that to either just accept that or to deal with it. I think chances are often they're going to choose the latter, not the former. And what they're going to be required to do is to initiate an adjudication. So what we can see then is these strands of reform coming together here. We want the prompt payment, we want the holdback monies to flow, but we also don't want to have a massive amount of legal litigation process in the way of coming to a resolution of that issue. We're going to encourage people to go to adjudication to get that done. The other modernization points, I think, go to the whole, the old act was last done in 1983, and the way construction projects are delivered had moved on significantly. So to provide for, holdback on multi-year projects in phases or on an annual basis, to segment it when you can clearly identify discrete improvements under a single contract. And the last point, actually, that you can enter into a deferral agreement to allow for early holdback release are all important. I would argue, actually, that all these things are available under the current Construction Lien Act, but again, there was a complaint that they were perhaps too cumbersome, too difficult to understand and implement on the ground. And to simplify, clarify the ability to allow holdback to be released early in a project was a necessary reform, and that has now been put forward with these provisions. So I want to end then with 2 points under the holdback issue. This is, to me, I think, an absolutely fundamental change. The first point on my slide here about a demand-worded holdback repayment bond. And indeed, over the years, I'd had a lot of clients ask me about this. Do we need to have actual cash retained somewhere in a bank account, or could we just post some other form of security so that we're good for it and have the cash flow? As I read it, and again, you can look at this draft form of bond right on the ministry website, there's going to be an ability to do that if you post a demand-worded holdback repayment bond in lieu of having the owner actually retain the cash. So It's going to be interesting. That's going to allow some cash to flow, but it's going to create definite risks. Liens are still going to be in place, and Andrew's going to talk about, how that's going to work under the new act. But if a lien's registered and that holdback money has not been paid by the contractor to their subs, then there's going to be very little scope under a demand-worded instrument, something almost like an LC, for the surety to refuse to pay. So, and of course, these surety companies don't give out these bonds for free. They want an indemnity for that. So, it's going to be interesting to see how this plays out, but I think people are going to try to game the system by getting cash and then dispersing it as they go without being accountable for it, are going to find that the hammer is going to come down eventually in the form of the bonding company having recourse there. And then last, this is an interesting one, just a geeky little point, if you'll bear with me, is that I talked earlier about the notice of intention to set off, that it drives an adjudication process. Absolutely true, but it's interesting you got this weird period between July 1st, 2018 and October 1, 2019, where the adjudication regime, including the establishment of the nominating authority and having all the regulations in place, is not going to be there. So what do you do during that period? I think the answer is twofold. One is, this may be naive, but I would advocate that the parties might consider, given that that's the way we're going, is resorting to some form of adjudication process in the interim if they can agree on an appropriate person to conduct that adjudication for them. The other reality, I think, frankly, is it's going to lead to litigation. There's going to be liens. There's going to be lawsuits, because I think if you're a contractor receiving that notice of intention to set off, what you're not going to want to do is just sit on it and do nothing. So I think there's going to be litigation. I think it's a good thing, therefore, that the government is indeed advertising for a new master's position with the retirement of Master Albert later this year, because I think this is going to be a hot issue. So at that point, then, thank you. I'd like to turn it over to my partner, John Margie, who's going to talk about prompt payment.
Great. Thanks, Brendan. The timeliness of prompt payment has always been an issue in the construction industry. Currently, payment cycles may lag as long as 120 days. Elongated payment cycles are crippling to the industry and can have serious consequences, such as causing contractors to lay off workers, decline to take on more work, and including a contingency in their bids to known late payers. Ultimately, late payments drive up the cost of construction. Prompt payment was developed first in the US, then in the UK, and has since been adopted by many other Commonwealth countries. The Ontario prompt payment regime was based on some elements of the US and the UK prompt payment models. From the US, the Ontario regime adopted the concept of a proper invoice as a trigger for the payment timelines. From the UK, Ontario adopted adjudication and integrated adjudication with prompt payment to allow for enforcement of the prompt payment provisions in a summary and timely manner while the project is still ongoing. The Ontario prompt payment regime attempts to balance mandatory prompt payment and the principle of freedom of contract. The legislators have tried to maintain some freedom of contract by permitting a payer to deliver a notice of non-payment to dispute the amount of the invoice pursuant to the negotiated terms of the contract. Before I get into the details of prompt payment, it's important to review the two types of documents that are central to prompt payment. The first is a proper invoice, and the second is the notice of non-payment. A proper invoice is defined in the new legislation. A proper invoice has several requirements which must be included in the invoice in order to trigger the payment timeline. Some of the requirements of a proper invoice are easily understood, and others will likely require an interpretation by the courts. The requirements are all set out on the slide. I want to briefly address numbers 3, 4, 5, 7, and 8. With respect to number 3, it's not clear what is intended with this provision. Perhaps it will be sufficient to refer to the written contract as the authority. In the case of an oral contract, perhaps it will be sufficient to refer to the direction to proceed with the work. With respect to number 4, providing a description of the services or materials that were supplied, this requirement is somewhat vague as the level of detail required is not clear. Does the contractor have to provide a detailed description of every single activity in the month? Will it be sufficient to provide a copy of the contractor's daily reports for the month? With respect to number 5, the payment terms must be included in the invoice. At a minimum, the payment term should refer to invoicing monthly and payment within 28 days as prescribed by the Act. If the contract provides something different, such as milestones, those should be set out on the invoice. However, the proper invoice for a milestone must also be paid within 28 days of being given to an owner. Number 7 refers to any other information that may be prescribed in the regulations. At this time, the draft regulations do not set out any single requirements for a proper invoice. However, parties will have to check the regulations on a regular basis to ensure compliance with any new requirements. Number 8 is any other requirements that the contract specifies. There are 2 ways to look at this. The first is that the parties are free to negotiate any other requirements of a proper invoice and include them in the contract. Contracts typically require WSIB clearance certificates and statutory declarations to be provided with a draw request. The second way to look at this is that it permits an owner to impose additional and potentially onerous requirements for a proper invoice. Example of more onerous requirements include monthly reports, an accurate, updated CPM schedule, proof of payment to subcontractors, waiver of all claims to the date of the invoice, and a current list of outstanding deficiencies and their value. This last example could be particularly troubling where a contract permits the owner to withhold an amount equal to twice the estimated cost to repair the deficient work on the list, and then use this as the basis to pay less than the invoiced amount. However, in order to ensure that payment cycles are shortened by the new legislation, as intended, the legislators opted to limit an owner's ability to affect or circumvent the promptness of payment. Contract terms that require prior certification by a payment certifier or owner approval before an invoice can be given by the contractor are rendered unenforceable by the legislation. There are 2 significant exceptions to the prompt payment regime with respect to alternatively financed projects. First, contract terms that require certification of a payment certifier or approval of the owner before an invoice can be rendered are in fact permitted. Second, prompt payment only applies to the construction portion of an alternatively financed project, so that prompt payment will not apply to the operations and maintenance portions of the contract. The legislation stipulates the delivery process for a proper invoice, and in particular, that the proper invoice be given. So under the Act, how do you give a document? The invoice can be sent by certified or registered mail. It can also be served in any manner permitted under our rules of court, such as personal service, which is to physically hand over the proper invoice to the other party. The parties may want to include a term in the contract that permits a proper invoice to be given by email or through an electronic document exchange service. How the document is given is important, as the payment obligations are not triggered until the invoice is properly given. So if you send the invoice by registered mail, the Act deems it to be given on the 5th day following the date on which it was mailed. Choose carefully how you give your invoice, as it could extend the payment timeline. The second type of document that underlies the prompt payment regime is the notice of non-payment. The different forms of notices of non-payment are in the regulations, which, as Brendan mentioned, have yet to be finalized. The correct form needs to be used based on whether the party giving the document is an owner, contractor, or subcontractor. In addition, the correct form needs to be used based on the circumstances, whether the non-payment is a result of a failure to pay with no notice, or whether the non-payment is a result of a dispute with a notice of non-payment. The regime is designed so that full payment is made or some payment is made and a notice of non-payment is given for any disputed amount. The failure to give notice of non-payment should result in full payment. The Act requires undisputed amounts to be paid. The timelines are designed to permit the parties to decide what they want to do and to give the appropriate notices. Where the owner or a contractor makes partial or no payment without a notice of non-payment, then the contractor uses a Form 1.2 notice and the subcontractor uses a Form 1.4 notice that are given to the party below them in the pyramid. The significant feature of using these two forms is that the contractor or subcontractor undertake to adjudicate the partial or non-payment within 21 days after giving the notice of non-payment. On the next slide, I've included the current version of Form 1.2, and you can see the undertaking by the contractor to take the matter to adjudication. The second set of forms of non-payment are used where partial or no payment is made due to a dispute. The owner is required to set out on the form the amount that will not be paid. More importantly, the owner is required to detail all of the reasons for non-payment. That being said, the level of detail required is not clear. For example, is it sufficient to merely state defective work, or is an owner required to detail each item of deficient work and attach a price to it? Will a party be required to refer to a specific contract term in the notice? The courts will likely have to provide some guidance on these potential issues. On this slide, I've included Forms 1.1 and 1.3. You can see that each form includes the requirement to set out the reasons for non-payment. So those are some of the concepts and forms around the basic framework of prompt payment. In terms of timelines, the next slide sets out the time within which full payment is to be made down the construction pyramid. The triggering event is the receipt of a proper invoice by the owner from the contractor. The owner then has 28 days to pay the contractor, and all others in the pyramid pay the party below them within 7 days of receiving payment. This slide sets out the timeline for the notice of non-payment where the owner makes only a partial or no payment to the contractor without giving a notice of non-payment to the contractor. The contractor will provide a notice of non-payment to its subcontractors within 35 days of giving the proper invoice. All others in the pyramid will give a notice within 7 days of receiving the notice from the contractor. Note, however, if a partial payment is received, the contractor must make a corresponding partial payment to its subcontractors on a ratable basis and give notice of non-payment for any amount that is not being paid to the subcontractor. The failure to make a payment in compliance with these rules will attract notable consequences. First, late payment interest will accrue at the rate specified in the contract or the Courts of Justice Act. Second, an adjudication will be held, and if the amount determined by the adjudicator is not paid, the contractor may suspend the work, claim the cost of the suspension, and enforce the determination from the adjudication. This slide sets out the timelines for the delivery of the notice of non-payment where there is a dispute. The owner is required to give its notice of non-payment within 14 days of receipt of the proper invoice, and all others in the pyramid give a notice of non-payment within 7 days of receipt of the notice from the party above them. With respect to payment, the undisputed portion is to be paid by the owner. As in the previous slide, where a partial payment is made by an owner and no subcontractor is specifically implicated to have caused the partial payment, then all subcontractors are paid on a ratable basis. Where, however, a partial payment is made by the owner as a result of a dispute related to certain subcontractors, then the implicated subcontractors are paid on a ratable basis, if at all, and all other subcontractors who are not implicated in the dispute are paid in full. This slide sets out the applicable timeline where there is no dispute between a contractor and the owner pays in full, but there is a dispute between the contractor and a subcontractor. The owner would pay within 28 days. However, the contractor, within 35 days of giving the proper invoice, would send a notice of non-payment to the subcontractor that it has a dispute with, and that subcontractor would give a notice of non-payment to those below it in the pyramid within 7 days of receiving the contractor's notice. In conclusion, prompt payment is now the law of Ontario, and that regime will come into force on October 1, 2019. This gives all industry players an opportunity to review their processes and documentation and make any necessary changes so that they can comply with the prompt payment provisions. The regime is simple: either pay or provide a notice. The consequences of failing to comply will be costly. So I guess now Keith and Andrea will step in.
Here we are, 5 things to know. And what I'd like to start with are 5 fundamental points. Number 1, statutory adjudication has its origins in the United Kingdom, where they do not have any equivalent lien legislation. That's interesting, as Brendan put it, us construction law geeks, to see how that's going to work with lien laws that exist here in Ontario. 2, statutory adjudication in Ontario will have minimum requirements that one cannot contract out of. 3, statutory adjudication will allow for real-time dispute resolution. 4, the appointment of adjudicators will be controlled by an authorized nominating authority. And 5, the court's role will be very limited. Starting with point 1, the origins of the statutory adjudication. In the United Kingdom in the early 90s, the construction industry was being crushed by its litigation costs and cash flow delays. An inquiry was launched and a report was given, and as a result, real-time, interim binding dispute resolution was offered as a solution. And the government imposed a set of minimum standards for statutory adjudication. By 2003, 7 years after the statutory adjudication legislation had been put in place, less than 2% of adjudicated outcomes had ended up in litigation. The success of statutory adjudication in the United Kingdom served as a blueprint for the launch of the statutory adjudication scheme here in Ontario. That's why it's important to look at the fundamental points of the scheme in the UK, as we have up here on the screen, because the spirit of these 8 fundamental points have made their way into the Construction Act. First, the right to refer a dispute at any time. A party to a construction contract does not need to wait until the project is finished in order to have a dispute determined. As set out in number 2, notice requirements, it has the right to refer that dispute to an adjudicator at any time. There's no preconditions preventing them from doing so. Number 3, the appointment of an adjudicator and providing them with the details of a dispute must take place within 7 days of first serving the notice of that dispute. Number 4, 28 days to an adjudicator's decision. I believe this timeline's been varied with the Ontario legislation, but trust me, it's pretty close. It needs to be done pretty quickly. Due process. An adjudicator is required to act impartially. And number 6, inquisitorial jurisdiction. The adjudicator must take the initiative in ascertaining the facts and the law. This gives the adjudicators the power to investigate the issue in whatever manner they deem appropriate in light of the short timescales they have available to work with. 7, the decision of the adjudicator is binding until the dispute is finally determined, and it will be enforced by the court if necessary. 8, adjudicator immunity. Your adjudicator is not liable for anything they do as the adjudicator unless they acted in bad faith. Sorry. Now, at the contracting level, there are minimum requirements provided for in the Act. First, the adjudication scheme applies to all contracts and subcontracts. Second, all of those contracts are going to have to abide by minimum requirements. And at the time of contract, there'll be no extending the timelines. The parties may contract for a shorter timeline, but they can't be extended at the time of entering the contract. The statutory adjudication scheme, therefore, cannot be avoided. We must all learn how to work with it. The process is started by the service of a notice of adjudication. The notice should set out the particulars of the dispute and specify the redress being sought, whether it be cash allowances or an extension of time. The parties then may agree to the appointment of an adjudicator that must be prescribed by the authorized nominating authority. And this is done by sending a notice of adjudication to the desired adjudicator. Where the parties fail to agree to an adjudicator, or the requested adjudicator does not consent to the adjudication within 4 days, the party who gave notice will request the authorized nominating authority to appoint an adjudicator. The authorized nominating authority will then appoint an adjudicator to conduct an adjudication no later than 7 days after receiving the request for an appointment. No later than 5 days after an adjudicator agrees or is appointed, the party who gave the notice of adjudication must provide the necessary documents for adjudication. Interestingly, there's no provision for the responding party to deliver their documents, and I think it's implied then that the adjudicator will impose a process or a deadline for them to provide their documents, or this will later be filled in by regulation. No later than 30 days after receiving the referring party's documents, the adjudicator must make a determination, with written reasons. The entire process should only take 46 days, and these interim decisions would remain binding and enforceable until the conclusion of the project, at which point in time it may be resolved finally, either in court by way of arbitration conducted under the Arbitration Act. A party faced with an adjudication or a notice of adjudication will only have a few weeks to gather all of the documents and information they need to respond and present their case. Having a team that can react and effectively respond to these aggressive timeframes will provide a huge advantage to those engaged in this process. Now, the authorized nominating authority is a huge change here in Ontario. It's going to be somebody that will be designated to be the authorized nominating authority, and they'll be responsible for the following: developing and overseeing programs for the training of persons as adjudicators, qualifying persons who meet the prescribed requirements as adjudicators, establishing and maintaining a publicly available registry of adjudicators, and appointing adjudicators for the purposes of subsection 13.9, but simply mean you can't be an adjudicator unless you're appointed, and a party can have an adjudicator imposed on them by the authorized nominating authority. This is a big change, as I mentioned earlier, because as the current system stands, the parties, of course, in their freedom of contract, can appoint a dispute review board, a project mediator, or an arbitrator, and they're able to agree to that person at the point of contract. And there's no basic certification process or nominating process in place at a statutory level. That's no longer the case. You can no longer have a standing project mediator that would take the place of your adjudicator. Instead, the adjudicator may only be selected after the notice of dispute has been issued and only picked from the registry, which we've heard is done by the authorized nominating authority. Now, the adjudicator powers are similar to the UK, and they include some big changes in how an adjudicator may determine a dispute. One, the inquisitorial method, as we mentioned earlier, they may take initiative in ascertaining the relevant facts and law. Two, they may draw inferences based on the conduct of the parties. Three, they may conduct on-site inspections. Four, they may obtain the assistance of a merchant, accountant, actuary, building contractor, architect, engineer, or any other person they see fit that may be required to provide the needed expertise they need to make a determination. They'll later fix the fee of such assistance and direct the parties to pay that person. And this is a non-exhaustive list of the adjudicator's powers. Essentially, the act that gives the adjudicator the power to do whatever needs to be done to craft a process to resolve a dispute within the very tight timelines provided. The court will have a limited and very narrow role in this process. Under the Construction Act, the court's role will be limited to determining if an adjudicator's determination should be put aside or enforcement. There are very limited grounds on which an adjudicator's determination may be set aside, and they're essentially legal capacity or jurisdiction, the same as you would set aside an arbitral award. Clearly, this is done to limit the role of the courts in the adjudication process so that Ontario ends up with a very similar result as we found in the United Kingdom. We lighten the court's load and we save on litigation costs across the province and for the construction industry. Now, in 2006, our partner Duncan Glaholt wrote an article called "The Adjudication Option: The Case for Uniform Payment in Performance Legislation in Canada." And I'll read from that article. Duncan wrote, "We need a nationally uniform process to obtain and enforce orderly, timely solutions to all problems in the Canadian construction industry as they arise, not after the fact when it's too late to matter." Statutory adjudication is going to radically change the way and the time in which construction disputes are resolved. When a dispute arises on a project, whether it be an issue of cash flow or delay, it will no longer hang over the project for its duration or have the power to stop the project in its tracks. Instead, the dispute will be resolved within the approximately 40 days of it being raised, allowing for a swift resolution and resumption of the project. Perhaps after the Ontario system has also become tried and tested, other Canadian jurisdictions will follow its lead, and we may end up closer to that nationally uniform process. Thank you.
Good afternoon, everyone. My name is Andrea Lee. I will be presenting the fourth and final segment of today's webcast. So if you have any questions now on anything that you may have heard so far, we encourage you to submit them through the chat function so that they can be addressed at the end of the webcast. And as Brendan had introduced, my topic will be the preservation and perfection of liens under the new Construction Act. The Construction Lien Act currently provides for a time frame of 45 days following the earlier of the publication of a CSP or the completion or abandonment of a contract. And when the expert review was preparing its report and consulting with industry stakeholders, many indicated that they felt this time frame was too short, and it was based on a period of time where billing cycles were more in the range of 30 days. And today we are finding that those payment cycles are actually extended. And so the recommendation was made that the time to preserve liens be extended to 60 days, and that recommendation was adopted. And so starting July 1, 2018, the new subsection 31(2) of the Act will provide a lien claimant with 60 days to preserve its lien following the conclusion of the earlier of the date on which the certificate of substantial performance was published, or the date the contract was abandoned, completed, or terminated. Now, adding the termination of a contract as a triggering event is something that is new and was recommended in the report. Many felt that there was a gap between when a contract is completed and abandoned, and there were cases where contracts were simply terminated, and it was unclear what the triggering event for the lien period would be. And so now this is being written into the legislation. Subsection 31(6) of the Act will set out that once a contract is terminated, a notice of termination must be published by an owner, a contractor, or any other person whose lien is subject to expiry in the manners provided for in the regulations and in the prescribed form. So there is currently a proposed prescribed form for the notice of termination. However, the regulations, which have not yet been finalized, simply state that the notice must be published in a construction trade newspaper. There's no mention of the timeframes within which it must be published. And so it is important to note it is not the date of the publication of the notice of termination, but the date the contract was terminated, as set out in that notice. And so it remains to be seen how the lien times will be affected if, for example, a notice of termination is not published until some 20 days after the contract has in effect been terminated. There are also some new timeframes for perfection. Under the current Construction Lien Act, a lien claimant must perfect its lien within 45 days following the previous 45-day period during which it has to preserve its lien. So when the report striking the balance was prepared and industry stakeholders were canvassed, many viewed this time period as being simply too short to allow for any meaningful settlement discussions between parties. And further, they canvassed other jurisdictions in Canada and found that, in fact, other jurisdictions had longer time frames to perfect liens. So the recommendation was made and adopted that the time frame of 45 days be extended to 90 days. What still must be done, though, is an action must be commenced in the jurisdiction where the premises are located. A certificate of action must still be registered on title if the lien is registered and no vacating order has been obtained. You must still serve the statement of claim within 90 days of the commencement of the action, and you still must set the action down for trial within 2 years of the commencement of the action. Now, currently, under the Construction Lien Act, lien claimants who perform work on premises owned by municipalities which are not public streets or highways are required to register their liens on title. And when the expert review was conducting its interviews with many industry stakeholders, a number of parties felt that municipalities are not likely to go bankrupt. In fact, they're not authorized to go bankrupt. And there's less concern about securing claims against the land. And in any event, it was considered against public interest for a lien claimant to be able to sell municipally held lands. And so on October 1 of 2019, changes will come into effect which provide that a lien will no longer attach to the interests of a municipality in any premises. From that point forward, the lien will have to be given rather than registered. And at that point, the lien will become a charge against the holdbacks required to be retained. There are also some new rules when it comes to registering against condominiums. When the report striking the balance was prepared, there were 3 recommendations made with respect to liens and condominiums. The first recommendation, after consulting with many industry stakeholders, was that it is simply too burdensome and costly for lien claimants to be required to register liens against every single PIN in a condominium building. So the recommendation was that a single PIN be created for the common elements against which a lien could be registered, and all unit owners would be subject to this lien. The second recommendation was that a notice of a preserved lien would have to be given by the lien claimant to the condominium corporation and unit owners. And the third recommendation was that in order for a unit owner to vacate a lien against its unit, it would only have to put into court security proportionate to its share of the lien. Now, of these three recommendations, only the first one does not seem to have been adopted in the new Act. And so as a result, you still have a situation where lien claimants must register liens against all units in a condominium building. And it appears, in addition, that now a lien claimant will also have to give notice of the preserved liens to condominium corporations and individual unit owners. Further, under subsection 31.2 of the Act, currently it provides that a notice of intention to register a condominium must be published in a construction trade newspaper no later than 5 days and not more than 15 days, excluding Saturdays and holidays, in advance of a condo being registered. And this is really to give notice to the industry that the condo, which might have been 1 or 2 pins, will be broken up into several hundred pins. And now, with the change under the Act, it looks like that section has been amended to read simply that a notice of intention to register must be published in the manner set out in the regulations. Unfortunately, the regulations are currently silent as to the manner and timing of such publication. And so hopefully in the future they will address that and provide some dates and parameters around publication. My partner Keith talked to you a bit about adjudication, and as he mentioned, the adjudication provisions will come into effect in October of 2019. Now, subsection 3410 deals with the timing of liens when an adjudication is underway. Now, that section provides that if the subject of a lien is also the subject of an adjudication, the lien will be deemed to have expired on the later of the date on which it would expire under Section 31 of the Act, and 45 days after the adjudicator receives documents under Section 13 of the Act. Now, what's interesting here is, and Keith touched a bit on the time frames, but Section 13 provides that an adjudicator shall consent to his or her appointment within 4 days of the delivery of the notice of adjudication. Otherwise, a nominating authority shall appoint an adjudicator within the following 7 days. So this would be a maximum of 11 days before an adjudicator would have to be selected. Documents are supposed to be delivered to an adjudicator 5 days after the adjudicator is appointed. And so if you add up these time frames, you get 11, 5, 16. So a lien could expire at any point between 45 days and 61 days after a notice of adjudication has been given. The Construction Act currently provides that a notice of adjudication shall be given to the other party to a contract or subcontract. And it also states that if the regulations so provide, a copy of the notice of adjudication will be given to prescribed persons or entities. The regulations are currently silent as to whom copies of the notice of adjudication will be given, so it remains to be seen how, for example, a supplier far down the chain may know that a contractor has initiated an adjudication with the owner. And it is also unclear how the deadlines for liening will be affected if separate adjudications are consolidated and documents are delivered to the adjudicator at different times. Now, I'd like to talk a bit about the transition rules because they've caused some concern amongst many people reading the new legislation. And as we mentioned at the outset, on July 1st, 2018, the modernized construction lien and holdback rules under the Construction Act will come into effect, and on October 1st, 2019, the prompt payment, adjudication, and rules regarding liens against municipalities will come into effect. Now, subsection 87.31 of the Act will also come into effect on July 1st, 2018, and this is a section that deals with transition into the new Act. So this subsection provides that the Construction Lien Act will continue to apply with respect to an improvement if a contract for the improvement was entered into before July 1, 2018, regardless of when any subcontract under the contract was entered into, or a procurement process for the improvement was commenced before July 1, 2018 by the owner, or the premises is the subject to a leasehold interest, and that lease was entered into prior to July 1, 2018. There's a reference to subsection 2, sub 2 of the Construction Lien Amendment Act 2017, which appears somewhat out of place, as that refers simply to the definition of a construction trade newspaper. However, essentially what the transition provision is saying is that after July 1, 2018, if you've entered into a contract after that date, or if the procurement process starts after that date, or if the lease concerning the premises starts after that date, then the new act will apply. Subsection 87.32 provides examples of the commencement of a procurement process and includes the making of a request for qualifications, RFPs, or calls for tender. However, it does leave open for interpretation what other processes might trigger this time frame. For example, if an owner is seeking proposals from design professionals, for example, to conduct a feasibility study long before the project is even commenced, this might be considered to trigger the whole procurement process, and the improvement might still be considered under the old Construction Lien Act rather than the new Construction Act much later. And on October 1st, 2019, Section 87.3 sub 3 will be added, and this deals with prompt payment and adjudication, and it simply states that those rules will apply to contracts entered into after October 1st, 2019. Now that's a little bit more straightforward. I think that the subsection 87.3 sub 1 could lead to some uncertainties with respect to the transition rules, and might end up in a number of unintended scenarios. Brendan spoke to a few, but for example, if improvement is performed on premises which are subject to a lease that was entered into now, and it's 2030. That contractor may still have to look to the Construction Lien Act to determine the timing of its liens. And not only that, the new Construction Act provides that a landlord's liability is really subject to only 10% of the cost of the improvement, whereas the current Construction Lien Act makes the landlord's interest subject to the same extent as the leasehold owner, where a Section 19 notice has been delivered. And so, in our view, there are a number of uncertainties, and given the uncertainties, we would recommend a few practical tips for preserving and perfecting liens going forward. When in doubt, always follow the shorter time frames. Always check online for the publication of any CSP notices of termination, and if the regulations are amended, notice of intention to register a condominium. One should check to see whether liens must be given or registered on title under the new Act. And one should also check to see whether notice of preservation of lien must be given to any party. And finally, the key practice point would be always to diarize the timelines in your calendar. So on behalf of the firm, we'd like to thank you for participating and joining us for this webcast. Please, again, send any comments you may have either in the chat box or to us later at info@glaholt.com. If you would like a PDF copy of this presentation, we can make one available to you. And if you want to revisit this webcast for any reason at a later date, it will be made available on our website later this week. Thank you.